Hi everyone, this is Dimitris Koulafetis. In this video, I will talk to you about sexual harm prevention orders. Before I do so, I would like to issue a disclaimer, say that nothing in this video should be construed or be relied upon as legal advice, or does necessarily reflect the latest legal developments. So having done so, I will proceed with the rest of my video. Now, sexual harm prevention orders came into existence on March 3rd, 2015 by an amendment by the Antisocial Behavior Crime and Policing Act 2014 to the Sexual Offenses Act 2003, repealing the predecessors called SHPOs and replacing them to the extent that they were applicable in England and Wales, and replacing them with sexual harm prevention orders. SHPOs, sexual offences prevention orders, are still in good standing in Northern Ireland and Scotland. So the main differences between the predecessors and sexual harm prevention orders are that the name has changed. Another difference is that the definition of child has changed within the Act that applies to sexual harm prevention orders. Thus they have increased the ambit of the order so as to include within the definition of child persons that are under the age of 18, whereas that was not the case with sexual offences prevention orders. A child was someone who was under the age of 16. Another difference is that sexual harm needs to be protected in sexual harm prevention orders rather than serious sexual harm that was the case with the predecessors. So there's changes just go to show the TAF stamps that the state is adopting in combating sexual offenses. They can severely violate a person's civil rights, possibly the right to double jeopardy, and his rights under Article 8, which provides for the respect of someone's private or family life. So in a case that somebody needs to be left alone, given the severe nature of these orders, which cannot really be compared to a simple restraining order, since they do have long-term consequences on the person that they are imposed on. For example, they can isolate him, they can limit his employment potential, they can even subject him to harsh criticism, and to even risk his bodily integrity by people that have notification about who he is, that he is a registered sex offender, although he could have been convicted, or he could have been even not convicted, like he could have been even cautioned by an offense which had some sort of little sexual aspect to it. But because of that, these orders could apply by a passionate judge and have really undesirable results on the overall criminal justice picture, if you look at it like from a general perspective. So when are these orders made? Now, these orders are made when a court deals with a defendant in respect of an offense that's listed in Schedule 3 and 5 of the Sexual Offences Act 2003, or when a defendant is found not guilty of an offense listed in Schedules 3 or 5 by reason of insanity, or a finding that basically the defendant is under disability and he has done the act charged against the defendant, against him, in respect of an offense in Schedules 3 and 5, and the court's got to be satisfied that is going to be necessary to protect the public or any particular members of the public or children or vulnerable adults generally, or any particular children or any particular vulnerable adult outside the United Kingdom. Another way in which these orders are made is when the Chief Officer of Police or the Director General of the National Crime Agency makes a complaint by way of application to the Magistrates Court, mentioning basically that the individual concerned is a qualified offender, and a qualified offender is a person that hasn't necessarily been found guilty of the relevant offenses which I mentioned in an earlier section of this video, but he could have been cautioned. So this person could be a qualified offender, and that since the appropriate date, which under the Act is a date when he was either convicted or cautioned about the relevant offense, that he act in such a way as to give a reasonable cause to believe that such an order needs to be made. Now, these orders last for a minimum of 5 years, and you can see here the very tough approach that the government is taking in combating sexual offenses and sexual crime in general, because they not only have they lowered the standard of what's necessary to impose such an order with regards to sexual harm prevention order, as opposed to SHPO, which is that of harm as opposed to serious sexual harm. And sexual harm under the Act presently includes psychological harm too. So what is this Act, and how do you judge a person based on something that he might potentially commit in the future? And another aspect of the seriousness of these offenses is, since if it's 5 years and a person has been and a person is dealt with in respect of an offense that's listed in the Act, which does not morally deserve to such a huge public outcry and such strong prohibitions on this person's liberties, but because maybe the offense that he was dealt about had a very little sexual aspect to it, or now he is being caught by that order, the sexual harm prevention order, and he will be for at least 5 years of his life. So that's something that needs to be looked at, I guess, because this should not really be a one-size-fits-all approach, and there are definitely levels of seriousness to one's offenses, no matter what they are labeled. And these orders, and when breaching these orders, you can go to jail for about 5 years. So this is another consideration. Now, there is an argument that these orders breach somebody's private rights. I don't want to underestimate Parliament's efforts in combating sexual offenses. We all know how brutal and horrible these offenses are. But at the same time, we need to keep criminal justice a fair system where people are not going to be strained for life as a result of being caught by an order that is meant to deal with offenders that are very, very recidivist in nature. The effect of these orders is that they prohibit everything that's included in them, and it can be a wide range prohibition, which of course if someone has access to your private life out there in a democratic society, that interferes with your life to a very large extent. It does hinder your possibilities of getting on with your life. Now, this is what I wanted to talk to you about today: sexual harm prevention orders. I hope you enjoyed the video, and if you enjoyed it, just click the thumbs up below and subscribe to my channel for more videos like that.